This November, the Supreme Court dropped a massive ruling that completely redefines what it means to be a gun owner in America. I'm not exaggerating when I say this could be the most significant Second Amendment decision in decades. And in today's video, I'm breaking down the 7 new rules every gun owner must know before it's too late. Because here's the thing, this isn't just another legal update that only lawyers care about. This is a total game changer that affects whether you can carry, what you can own, and how states are allowed to regulate firearms going forward. So if you own a gun, plan to own one, or just care about constitutional rights, you need to stay with me through this entire breakdown. Let's dive in. So how did we get here? It all started after the Supreme Court's Bruin decision a couple years back, when several states decided they weren't going to let that ruling stop them from introducing new firearm restrictions. Some states tightened permit requirements, others expanded prohibited locations, and a few went so far that even moderate legal scholars raised eyebrows. One particular state pushed a law that essentially made it nearly impossible for average citizens to legally carry in public, despite what Bruin had clearly established. Lower courts were all over the place. Some struck down these new laws, others upheld them, and the legal chaos created a patchwork of conflicting standards across the country. That's when the Supreme Court knew it had to step in again. And the result? A new November decision that doesn't just clarify, it completely redefines what the Constitution really says about your right to keep and bear arms. Here's what you need to understand right up front. The Supreme Court didn't just make a small adjustment or tweak the language from previous cases. They redefined how the Second Amendment is applied at every level of government, federal, and state. The court ruled in very clear terms that any gun law, whether it's a ban, a permit system, or a restriction on where you can carry, must be consistent with the nation's historical tradition of firearm regulation. That might sound simple, but it's actually revolutionary. It means courts can't just decide whether a law seems reasonable or serves public safety. They have to ask, is there a historical precedent for this kind of restriction? And if the answer is no, the law likely violates the Constitution. Even more important, that standard now applies uniformly to all 50 states. There's no more wiggle room, no more regional interpretations. This is the new legal framework, and it's binding nationwide. Let's jump into the first major rule. From now on, states cannot invent brand new restrictions that don't have historical precedent. If a particular ban, permit requirement, or limitation on firearm ownership didn't exist in early United States history, specifically around the founding era or the time of the 14th Amendment, it's likely unconstitutional now. Think about what that means. States that have passed modern restrictions based on contemporary safety arguments now have to prove those laws are rooted in historical practice. For example, if you live in a state that requires extensive psychological evaluations before granting a carry permit, and that kind of requirement has no historical equivalent, that law is now vulnerable to being struck down. This puts enormous pressure on states like New York, California, New Jersey, and others that have built complex regulatory frameworks over the past few decades. Many of those frameworks are now on shaky legal ground, and gun rights advocates are already lining up lawsuits to challenge them. Rule number 2 gets into something that's been murky for years: the balance of power between federal and state governments when it comes to gun regulation. The ruling makes it abundantly clear that states cannot go beyond what federal law allows. In other words, if the federal government recognizes your right to own a certain type of firearm, a state can't just decide to ban it within its borders based solely on its own policy preferences. This doesn't mean states have zero regulatory power, but it does mean they can't override core Second Amendment protections. A quick example: several states have tried to ban standard capacity magazines, even though federal law has never prohibited them for civilian use. Those state bans are now under serious legal review, and many legal experts believe they won't survive this new Supreme Court standard. This is a huge shift in how federal and state authority interact, and it empowers gun owners to challenge state laws that go too far. Now let's talk about rule number 3, which is going to matter to anyone who carries a firearm for self-defense. The court has reaffirmed in the strongest possible terms that law-abiding citizens have the constitutional right to carry firearms in public for self-defense. This builds directly on the Bruin decision, but it goes even further by limiting what states can demand before they issue a permit. States can still have permitting systems, but they can't make the process so difficult, expensive, or subjective that it effectively denies the right to carry. For instance, requiring someone to show proper cause or good reason beyond general self-defense is now clearly unconstitutional. You don't have to prove you're in danger to exercise a constitutional right. Some states are already scrambling to rewrite their carry laws, and you're going to see a wave of legal challenges in the coming months targeting overly restrictive permit systems. If you've been denied a carry permit in the past because your reason wasn't deemed good enough, now might be the time to reapply or consult with a Second Amendment attorney. This next one is controversial, and it's going to spark a lot of debate. Rule number 4 addresses so-called red flag laws, which allow authorities to temporarily remove firearms from individuals deemed to be a threat to themselves or others. The court didn't strike down red flag laws entirely, but it strongly hinted that certain versions of these laws may violate due process protections guaranteed by the Constitution. What does that mean? It means states that allow firearms to be seized without giving the gun owner a chance to be heard in court first, or that set the evidentiary bar too low, are now on notice. Going forward, red flag laws will need much stronger legal safeguards. There has to be a genuine hearing, real evidence, and an opportunity for the accused to present a defense before their constitutional rights are suspended. Some states already have these protections built in, but others don't. Expect to see a flood of lawsuits targeting weaker red flag statutes, and don't be surprised if some of them get struck down entirely. Rule number 5 is going to be a game changer when it comes to federal agencies. The court, though it didn't address the ATF directly by name in every part of the ruling, indirectly limited the agency's ability to create or reinterpret gun regulations without clear congressional approval. For years, the ATF has stretched its authority by redefining terms, reclassifying firearms, and issuing rules that feel more like new laws. Think about the ghost gun regulations, the pistol brace ban, and various attempts to redefine what counts as a firearm or a machine gun. All of those moves are now facing renewed legal challenges, and many of them are unlikely to survive under this new standard. The court is essentially saying that agencies can't legislate from the regulatory desk. If Congress didn't explicitly give the ATF the power to do something, the agency can't just assume it has that power. This could be one of the most impactful long-term consequences of this ruling because it reins in bureaucratic overreach and forces any major changes to go through the actual legislative process. Now we get into rule number 6, which touches on an area of law that's been largely ignored until now, the rights of non-violent felons. For decades, any felony conviction, no matter how minor or unrelated to violence, has resulted in a lifetime ban on gun ownership. But this ruling has opened the door for nonviolent offenders to challenge those blanket bans. The court emphasized that constitutional rights are individual and that broad, one-size-fits-all restrictions may not hold up under strict constitutional scrutiny. Let me be clear, this doesn't mean violent criminals are going to get their guns back. It means someone who was convicted of a nonviolent white-collar crime or a decades-old felony that had nothing to do with weapons or violence may now have a legal path to restore their Second Amendment rights. It's a controversial shift, and it's going to be debated heavily in legal and political circles. But legal experts are calling it a major change in how we interpret constitutional protections, moving away from categorical bans and toward individualized assessments. Here's the 7th and final rule, and it's arguably the most important in terms of long-term impact. From now on, every federal court and every state court in the country must test new gun laws against this same historical standard. That means dozens, maybe even hundreds of pending lawsuits could flip overnight. Laws that were upheld under old standards might now be struck down. Regulations that seemed secure are suddenly vulnerable. This ruling doesn't just affect the specific case the court reviewed. It sets a binding precedent that lower courts have to follow. Imagine a domino effect. One state's assault weapon ban gets challenged and struck down. That creates momentum for similar challenges in other states. A city's ban on carrying in parks gets overturned. Suddenly, every similar ban nationwide is under legal threat. The ripple effect of this decision is going to be felt for years, and it fundamentally reshapes the legal battlefield for Second Amendment cases across the entire country. So, why does all of this matter? Because this isn't just legal talk that only affects courtrooms and law review journals. This reshapes how every single gun owner in America is treated under the law. Whether you live in a red state or a blue state, whether you're a lifelong gun owner or someone considering your first purchase, this decision affects you. It affects what you can buy, where you can carry, and how much red tape you have to cut through to exercise a constitutional right. The Supreme Court sent a very clear message with this ruling. Constitutional rights are not subject to the whims of political trends or regional preferences. They are fundamental, they are protected, and they cannot be eroded simply because some lawmakers think it's good policy. This is about preserving the core principles that define American freedom, and the court just reminded the entire nation that the Second Amendment is not a second-class right. Of course, not everyone sees it that way. The reactions to this ruling have been swift and divided. Gun rights groups are calling it the biggest victory since the Heller decision back in 2008. Organizations like the NRA, Second Amendment Foundation, and Firearms Policy Coalition are celebrating, saying this finally gives them the legal tools they need to dismantle unconstitutional laws nationwide. On the other side, gun control advocates are expressing serious concerns. Some warn that rolling back state restrictions could lead to increased gun violence and make it harder to keep firearms out of dangerous hands. Politicians are already responding. In some states, legislators are drafting new bills to comply with the ruling, while in others, governors are vowing to defend their existing laws in court for as long as possible. Social media has exploded with debate, and major news outlets are running opinion pieces from both sides. This ruling is not just legal, it's deeply political, and it's going to be a defining issue in upcoming elections at every level of government. So, what are the experts saying? Legal analysts across the political spectrum agree on one thing. This decision creates a much clearer framework for evaluating gun laws, but it also opens up entirely new debates. Constitutional scholars note that while the historical test sounds straightforward, applying it in practice is going to be complicated. What counts as a valid historical analog? How similar does a modern law have to be to a historical one? These are questions that will be litigated for years. Some experts believe this ruling will eventually lead to a more consistent and predictable body of Second Amendment law. Others worry it's too rigid and doesn't account for modern realities like the lethality of today's firearms or the challenges of urban gun violence. But one thing is certain, this case is going to be cited in nearly every major Second Amendment lawsuit moving forward. It's the new baseline, the new standard, and anyone arguing a gun rights case will build their arguments on the foundation this ruling just laid. So, what should you do if you're a gun owner? First, take the time to understand your state's laws, because many of them are about to change or be challenged in court. Don't assume that just because a law is on the books today, it will still be enforceable next year. Stay updated by following reliable legal sources, Second Amendment advocacy groups, and court filings. If you've been affected by a restrictive law, whether it's a denied permit, a confiscated firearm, or a ban on something you want to own, consider reaching out to a Second Amendment attorney. There may now be legal avenues available to you that didn't exist before. Join verified gun rights organizations that are actively litigating these cases. They need funding, they need members, and they need public support to keep fighting in court. And most importantly, always check the latest rulings and legal updates before carrying or purchasing firearms. The landscape is shifting rapidly, and what's legal in one jurisdiction might still be restricted in another until the courts sort it out. Knowledge is your best defense, and staying informed will help you navigate this new legal environment confidently and responsibly. All right, let's wrap this up. In short, this November Supreme Court ruling has redefined the Second Amendment, created 7 new legal standards that courts must follow, and completely reshaped the future of gun ownership in America. States can no longer impose restrictions without historical precedent. Federal and state power has been clarified. Public carry rights have been reaffirmed. Red flag laws are under scrutiny. The ATF's authority has been limited. Nonviolent felons may have a path to restore their rights, and every future case will be judged by this same rigorous standard. If you found this breakdown helpful, do me a favor. Hit that like button, share this video with other gun owners who need to know what's happening, and subscribe to the channel so you don't miss our next deep dive, because the legal landscape is changing fast, and I'll be here to break it down every step of the way. Coming up next, we're going to explore exactly how these 7 rules could overturn current bans in your specific state and what that means for your rights in the months ahead. Thanks for watching, stay informed, and I'll see you in the next one.